Strap in, this isn't traffic court. This is Texas justice under Judge Raquel West, where deferred probations, new charges, and hard resets collide. Today you'll see what a plea of true really costs, how a simple credit time calculation can shake a plea deal, and why one dirty UA can snowball into years. We've got multiple defendants. Theodore Briscoe, facing motions to revoke across 2 cases. Jaehan Young, renegotiating after a credit surprise. Jennifer B.S., with repeated positive tests and a big fee balance. Darren Walker, pleading to evading with priors. And David Wayne James, juggling a new felony while already on probation. Watch closely. Small choices trigger huge legal consequences. One judge has to weigh justice, safety, and second chances. Who walks out hopeful and who leaves in cuffs? Let's find out.
Good morning, sir. Good morning. Are you Theodore Briscoe?
Yes, ma'am.
And Mr. Briscoe, in cause number 234535, is on probation for evading arrest or detention with the use of a vehicle, and in 236055 on probation for possession of a controlled substance.
Yes.
Motions to revoke those probation have been filed. Mr. Parker, announcement.
Your Honor, just for the record, I went to see him at the jail, and they told me he wasn't at the jail.
Oh,
So I didn't get to visit him, and
Okay.
he was here. I got to visit him this morning. I told him that the court would probably give us more time to go over it if we wanted to, but I think we just need to go through the motion.
Without an agreement.
Without an agreement, I think he understands that. Also, there's a drug charge that hasn't been filed yet, just for the court's knowledge.
okay. And so, Mr. Briscoe, we can go through those motions today, get pleas of true or not true, or I can reset your case just a few weeks if you need more time to visit with Mr. Parker, since he, okay. So let me get that pulled up.
And they're the same violations on both cases, Judge.
Can I get 36055 printed, please? Oh, no, that's okay. I gotta make marks on it. Thank you. It's just hard to do when I do them both on the computer. All right, in each of these cases that we've talked about, Mr. Briscoe, again, I have motion to revoke your unadjudicated probation. In 20-34535, the motion shows that you were placed on probation March 15th of 2021 for the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle, and that was a 5-year deferred probation. Is that correct? And in cause number 20-36055, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 15th of 2021 for the 3rd-degree felony offense of possession of a controlled substance, and that was also a 5-year deferred probation. Is that also correct? Each of these motions allege that you violated your probation. Count 1 in each of the motions alleges that you committed the new offense of possession of a controlled substance January 5th of 2025 in Jefferson County, Texas, and is that true or not true? Count 2 in each case alleges that you committed the offense of assault causing bodily injury to a family member January 5th of 2025, and is that true or not true? Count 3 alleges that you committed the new offense of interference with an emergency request for assistance January 5th of 2025, and is that true or not true? Count 4 alleges that you failed to provide verification of performing the community service hours as required, and is that true or not true? And count 6 in each case alleges that you were behind in your court assessed fees, and is that true or not true? Did you enter your pleas of true in each case to counts 1, 4, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true? All right, then I'm going to find in each of your cases that you entered your pleas of true to counts 1, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case for sentencing.
What just happened to Briscoe exemplifies a master class in probation law. When he pleads true to specific violations, such as the new possession charge and missed obligations, the court can revoke deferred adjudication, enter a formal conviction, and sentence him. But notice the finesse. The judge finds the counts true and revokes, yet immediately resets for sentencing and orders an updated pre-sentence investigation. Translation: the court wants a comprehensive understanding history, compliance treatment, needs before deciding on punishment. Also key, the state plans to call witnesses on the counts Briscoe denied, so those disputed allegations aren't going away. Question for you: if you were the judge, would you focus on the new drug offense or the pattern of non-compliance when deciding the sentence?
Mr. Nichols, does the state anticipate bringing witnesses for either of those cases?
Yes, Your Honor, I'll have to call witnesses to prove up the two that
Sure.
he pled not true to.
Do you anticipate that taking longer than an hour or so?
No, I do not, Your Honor.
Okay, we'll just set it maybe at 11 on a regular docket day. I will ask probation to do an updated pre-sentence report. Mr. Briscoe, obviously anything that you think is important for me to know, make sure and get that information to Mr. Parker. He will present it to me on your behalf when we come back.
Yes, ma'am.
All right, we'll see you back at sentence. Yes, it's unagreed. God bless you.
Come over here.
Okay. Good morning. Are you Jacqueline Young? And
Judge,
Mr. Lewis?
Judge, we had an agreement on this matter. Of course, it's an MTRP and a new law violation. The plea was for 5 years on both cases to run concurrently. After looking at it, when we did the plea paper, we realized that it was a significant difference in the credit that he has on the MTRP and on the new case. I was going to ask, after seeing that and kind of talking to him about that a little bit, if I could get possibly 2 weeks so I could talk with him and as well as his mother. She's been pretty active in contacting. She's not here this morning, but.
Yeah, I mean, I'll do that. You'll have to redo the paperwork. I'll have to delete all that paperwork.
I'll go ahead and redo it.
And obviously, the fact that I don't know that, I mean, y'all can renegotiate, but I probably would not be inclined just because he doesn't have credit on a
Right.
new case that he's on to do that. But if you'll just explain that.
Right, I want him to totally understand what he'd be getting for
Sure.
parole-wise, eligibility and all that.
Okay.
And it's not going to be a reduction in the offer or anything, Your Honor. He wants time to make sure
Sure.
he understands what he's
Okay,
signed for.
we'll do a 2-week reset.
Okay, thank you.
Thank you.
This is why defense lawyers triple-check credits. Jae-Hun Young had a deal, 5 years concurrent on an MTRP, and a new sounds straightforward until the custody crediting math didn't add up across both files. Credits affect release calculations and sometimes eligibility downstream. One mismatch can make a good deal feel like a trap. The judge allows a 2-week pause so counsel can walk. Young and his family through the real-world impact, not changing the offer, just providing clarity. It's a reminder, the courtroom is about precise paperwork as much as it is about punishment. Engagement check. Would you accept a plea today if you weren't 100% sure how your time credits land?
Mr. Parker, you've got Jennifer Bowles. Let's see. Do I need to send that back to you and delete all those, I guess? Not on the other one, okay. Good morning. Are you Jennifer Bowles? Give me just a second here. And will Ms. Bowles waive the formal reading of the motion? Ms. Bowles, in cause number 18-29814, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 28th of 2019 for the offense of fraudulent use or possession of identifying information. That was a 3rd-degree felony, and that was a 10-year deferred probation. Is that correct? Yes. It alleges that you violated your probation. Count 1 alleges that you provided a urine sample October 24th of 2023 that tested, and October 25th, that tested positive for methamphetamines, amphetamines, and ecstasy. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample January 25th of 2024 that tested positive for methamphetamines and amphetamines. And is that true or not true?
True.
Count 3 alleges that you failed to provide verification of attending the DROP program January 2nd, January 17th, January 20th, January 29th, and February 5th of 2024. Is that true or not true? Count 4 alleges that you're behind in your court-assessed fees as of January 25th of 2024 in the amount of $4,972.61. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number
No
1.
objection.
It's admitted. Is there any evidence that Ms. Bowles is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. I'm sorry, find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty, and at this time find you guilty of the 3rd-degree felony offense of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 4 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. That will also run concurrently or at the same time with the Orange County case that you're currently serving any time on. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered.
Jennifer B.S. shows how quickly deferred can turn into time in TDCJ. Multiple positive UAs for meth, amphetamines, ecstasy, missed program dates, and nearly $5,000 owed. By pleading true to the violations, she essentially concedes the revocation roadmap. The court then follows the agreement. For years in the institutional division, concurrent with her Orange County time. Notice the judge's careful competency findings, and then the firearm admonishment. After this judgment, she's ineligible to possess firearms or ammunition under Texas law. It's a legal disability. Question: do you think a treatment-heavy sanction earlier could have prevented this outcome? Or were the repeated violations already too much for probation to absorb?
Against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. Good luck to you, ma'am. Thank you for being here, sir. Good morning. Are you Darren Walker?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
You will, Your Honor.
Let's see. Are we going on count 1 only? The state jail felony? Not all the
It's a
others?
state jail felony, yes.
Right, yeah, but there's all
Yes,
these
we're going-
priors.
yes.
Yeah,
Count 1 would be the previous invading, Your Honor.
okay. Now, hold on a second. Let me get this pulled up right. Mr. Walker, the state has elected to proceed on count 1 only. It alleges that you committed the offense of evading arrest or detention with previous convictions from October 19th of 2024 It alleges you were previously convicted of evading arrest or detention October 21st of 2011. And how do you plead to that charge? And is that prior conviction true? Did you enter your plea of guilty freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Walker is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of evading arrest or detention with previous convictions, sentence you in accordance with your agreement to a term of 12 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right? Good luck to you, sir. You can go back with the bailiff.
Thank you, Mr. Parker.
With Darren Walker, watch the charge framing. Evading arrest with prior convictions elevates the stakes. He pleads guilty. The court confirms he understands the rights he's waiving, and then sentences him to 12 months in the Jefferson County Jail under Penal Code. Section 12.44, that's the provision that can let certain state jail felonies be punished in county rather than state jail. Big difference in facility and day-to-day life. The court again issues the firearm ineligibility. Admonishment standard, but crucial. Here's the drama. Evading looks like a Runandan offense, but stack priors on it, and you're staring at felony consequences. Community question: should prior evadings automatically push jail time, or should courts weigh context, like why the person ran?
Typically try to take notice of that. It just didn't.
Did you notice that the jester was the best George we've ever had?
Good morning, sir. Are you David Wayne James?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment and the motion?
Yes, Your Honor.
Mr. James, in cause number 250522, you're charged with the third-degree felony offense of collision involving serious bodily injury from February 16th of 2025. And how do you plead to that charge?
I plead no contest.
You either did it or you didn't do it.
I plead guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Right.
All right. Then I'm going. I have here on the computer, in that case, some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, that's right.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Right, yes.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. And that, is that your understanding of your agreement?
Yes.
Okay.
The other case is, if you can't read my writing, it's extended probation and safety relapse.
Okay.
You can read it.
I guess the length of time in the probation is something that, obviously, the length of time on your probation, because it's even written on here, on this one, I can give you any amount of time in probation, so I don't have to follow that 5-year. If I give you the probation and sentence you to probation, the 10-year term in prison, probated for any number of years, you understand that you'll be waiving your right to appeal. So the thing is, until I see an updated pre-sentence report and really see what's been going on, just on the face of this, it makes me have a little bit of pause, because you're already on a felony probation and there's a new felony offense. And so I'm not sure that the length of time of only 5 years is something that I'm willing to go along with, but I'll take a look at it when we come back for sentencing. Do you understand?
Yes.
Your Honor, I've explained that to him, and I've explained to him that some courts don't even consider that. They automatically do it 10, but if you do everything you're supposed to do, the judge can always let you off probation early.
Correct. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation?
David Wayne James pleads guilty to collision involving serious bodily injury, a high-stakes charge with real victims and lasting harm. The deal envisions a 10-year term probated, suggesting 5 years of probation, but the judge signals a concern. James is already on felony probation and has a new felony. That's a red flag in any courtroom. Instead of rubber stamping, the judge orders a PSI and explicitly says she isn't bound to that 5-year probation length. Translation: the final term could be longer or conditions stricter, depending on the risk, needs, profile, and compliance history. Engagement moment. If you're on felony probation, should a new serious injury case still qualify for probation at all? Or does public safety demand incarceration?
Exclusion from admission to the country or denial of naturalization under federal law?
Yes.
State tender's number 1 in that
No
case.
objection.
It's admitted. Is there any evidence that Mr. James is not competent?
No, Your Honor.
All right, sir, in 250522, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I am going to reset your case so that the probation department can do a pre-sentence report, give me an update, obviously, on the probation case, as well as more information on this offense, and then we'll come back later for sentencing. Now, in cause number 1523545, I have a second amended motion to revoke your unadjudicated probation. Shows that you were placed on probation November 13th of 2017 for the offense of burglary of a habitation, a second-degree felony, and that was a 10-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of possession of a controlled substance, February 3rd of 2025 in Jefferson County, Texas. And is that true or not true?
It's true.
Count 2 alleges that you committed the offense of possession of drug paraphernalia on February 3rd of 2025. And is that true or not true?
It's true.
Count 3 alleges that you failed to avoid persons or places of disreputable or harmful character, specifically by associating with past associates who are actively using illegal substances. Is that true or not true?
It's true.
Count 4 alleges that you provided a urine sample September 23rd of 2024 that tested positive for cocaine. Is that true or not true? Count 5 alleges that you provided a urine sample January 27th of 2025 that tested positive for methamphetamine. Is that true or not true? Count 6 alleges that you failed. Nope, we're going to keep going. I want to know all of this if I'm going to consider leaving them on probation. Thank you, though. Count 6 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you provided a urine sample on February 3rd of 2025 that tested positive for alcohol. Is that true or not true? Count 7 alleges that you're behind in your court-assessed fees as of February 3rd, 2025 in the amount of $1,689. Is that true or not true?
That's true.
Count 8 alleges that that doesn't really give me.
Yeah.
All right, I'm going to skip 8. Count 9 alleges that you failed to report to the probation department as directed on February 7th of 2025, and is that true or not true?
True.
Count 10 alleges that you were at a location other than your residence at approximately 11:51 p.m. February 16th of 2025. Is that true or not true?
That's true. That's me.
Count 11 alleges that you failed to submit to the alcohol or drug screening as directed February 11th, February 14th, and February 19th of 2025. Is that true or not true?
That's true.
Count 12 alleges that you committed that new offense of collision involving serious bodily injury February 16th of 2025. And is that true or not true?
That's true.
Did you enter your pleas of true to all of the counts except, let's see, 8, which is the one that I left out, freely and voluntarily?
Yes.
And did you plead true to all of those counts because they're actually true?
Yes.
I have here on the computer some documents that have your signature on them in this case as well. Again, did you go over these with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
You understand if I follow the agreement that you've made with the district attorney that you would be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement in this case would be for me to continue your probation, extend it for 2 years, and order you to the Safe B Relapse program. Is that your understanding?
Yes.
State tenders number 1.
No objection.
It's admitted. All right, so I'm going to find that you entered your pleas of true to counts 1 through 12 minus 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case, again, to get an updated report about this case as well as a report about the other case, and we'll come back at a later date for sentencing. All right, you can go back with the bailiff.
That last segment is a probation reality check. In James's older burglary case, the state lists a long chain of violations: new possession, paraphernalia associating with users, positive UAs for cocaine and meth, alcohol, missed reporting, curfew breaches, skipped drug screens, and even the new collision causing serious bodily injury. Despite having enough to revoke outright, the agreement on the table is to continue probation, extend it 2 years, and send him to a safety relapse program, with the judge still demanding an updated report before finalizing anything. Big picture, this docket shows how Texas courts juggle accountability and rehabilitation, sometimes revoking, sometimes extending structure with treatment. Who do you think got the most merciful outcome today, and who needed a tougher sentence? Professional takeaway: deferred adjudication is a privilege. New law violations and dirty tests can turn it into a conviction with prison time. Judges rely on PS's credits math and compliance patterns to tailor sentences. CTA. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.